Now, one person we did hear from today for the first time, Karen Reed herself, doubling down, of course, saying she did not do this. She wants to know who did.
Said it feels we're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
And no, she didn't do it. No, she didn't do it. This is an innocent woman. She didn't do it.
I tried to save his life.
Yeah.
I tried to save his life at 6 in the morning. I was covered in the only one trying to save his life.
Why'd you admit to it?
She didn't admit to it. She didn't admit to anything close to that. Nothing close to that. And you should know that.
That was like 3 or 4 times she admitted to it.
No, she didn't.
That's not true.
She asked a question. She asked a question, which is very different. She didn't admit to anything.
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record.
Okay. How is everybody? Wanted to talk to you today about Turtleboy, and he's so happy. He says he's going to have lawsuit against his accuser, and he says there are 5 more for $2 million for defamation, and 5 more are coming. He says on X. We're going to look at his hearing for the restraining order from his accuser wanted to extend her restraining order, and he won. Spoiler alert, he won. My understanding of defamation law, and I'm not a lawyer, nor do I pretend to be one, but is that it has to harm your reputation. When you have a wild reputation like Aidan Kearney, I don't know if he can, I don't know how well he'll do saying that this is what ruined his reputation. When you have 19 witness harassment charges against you, when you put a doll and perform adult acts with it on your lap on a live stream, when you've said the things that you've said in public, I don't know how it's going to do as far as your defamation suit. I don't know how that's going to go over. But there is a link in the description of this video. I linked it on the live stream comments for the accusers. She needs a lawyer, and so please be generous and give to her. This is something, harassment is something I know a lot about, having reported on 2 cults that do this kind of thing. The Free Karen Reed movement is very much like Scientology. They will bull bait you. So if you don't know what bull baiting is, let me just pull this out for one momente and share my screen. So bull baiting is something that Scientology. So in the film, it says to have some forbearance and tolerance to take. So basically, it's a verbal assault. They assault you, attack you so much, and when you finally break, that's when they use that whatever film they can get against you. which is why Scientologists and free Karen readers are always filming. So Thoreau says it's just learning how to withstand verbal assault and not be as upset or show any visible reaction to unfriendliness, or just keep your composure against bull baiting. So and they also use retaliatory litigation. So Scientology got the idea to just keep people, NXIVM did the same thing, just keep people in litigation till they're out of money. It doesn't matter if you're right or not, until they're out of money, as a means to terrorize them and break them and punish them. And there's a term for that too. In America, it's called retaliatory litigation. I think I think there may be another even word, but here it's called vexatious litigation. Is a legal action which is brought solely to harass or subdue an adversary. It may take the form of a primary frivolous lawsuit, or may be repetitive, burdensome, and unwarranted filing of merited motions in a matter which is otherwise a meritorious cause of action. Filing vexatious litigation is considered an abuse of the judicial process and may result in sanctions against the offender. That's in England. I don't know if we have anything like that here. Oh, wait. They say these legal actions can occur. We do in the U.S., and which are specified below. So let's look in the U.S., since that's where I am, at least. I don't know where all my audience is. Scotland, United States, California. So here are the states that have it: California, Florida, Hawaii, Ohio, and Texas. None of them are New York or Massachusetts. So it doesn't really matter. But so, like I've been saying, Aidan Kearney has given himself a real education on the law. He thinks like a lawyer. And so often lawyers think like criminals. And he's given himself a real education on innocence fraud. And he has to be aware that where innocence fraud is most successful, and in my opinion, this is just my opinion, innocence fraud takes advantage of and really abuses our civil courts. So in civil court, the burden is much lower. You just have to prove to 51% more likely than not that something might be true. And this is where we see, so why I say innocence fraud campaigns, the purpose so much of the time is not only to push an ideology by freeing someone from prison and getting their case overturned, but the point is to sue for wrongful conviction in our civil courts and get multi-million-dollar payouts for totally, in my opinion, rightful convictions. And we see the Central Park 5 got $40 million. They wanted $100 million. Marty Tankleff got $13.3 million, I believe. So it's big money. And for these lawyers who see most of it. And it's making criminals rich and lawyers extremely rich.
We are here
from today, from the 7th. So when Marie Russell was giving her testimony, Aidan Kearney was in court with his accuser. Let's just call her LG, excuse me. And let's take a listen.
Attention of restraining order hearing, Ms. Lindsay Gaetani. I will give you this opportunity. I have read your affidavit. Is everything in that affidavit true and accurate?
I don't believe I submitted an affidavit.
Well, you submitted an affidavit originally with.
Oh, the first one.
Yes.
Okay. Yes.
Okay. And additionally, at this time, what I'll do, because I know you're not represented by counsel, I'll give you an opportunity to give a narrative, meaning you can tell me in your own words what you'd like to tell me for my consideration for purposes of extending the order. Counsel, then I'll give you an opportunity to cross-examine the plaintiff. And do you have any other witnesses you'll be calling now?
No.
Okay. All right, so whenever you're ready, you may proceed.
Thank you, Your Honor.
Good morning, Your Honor. I'm here respectfully to ask that my restraining order be renewed. I received a copy of the defendant's statement.
So you can also hear that she's representing herself, which, because she can't afford a lawyer, which is why there is a fundraiser. I encourage everyone to give. I certainly wouldn't encourage anyone to give to something that I wouldn't give to myself. But she's at an incredible disadvantage. And what they're going to bring up against her is that she foolishly broke and called up and threatened one of the flying monkeys who had called into a show, and she felt lied about her. I think that can be proven that that woman at least committed perjury in the hearing. We'll take a look at that. That comes in about the middle. I hope we'll get to all of this today. Maybe a long show, and we may skip around a little bit, but hopefully we will get all of it today. And this woman comes in and testifies for Aidan Kearney. Her name is Mary Bagwell.
Late yesterday afternoon, and I was able to review that. While I wholly disagree with most of the statement, I do realize we're not here to relitigate the original order, and rather for me to explain to you why I remain in fear as a defendant. So I first want to just express that the order is, my children are covered under the order as well. I remain in constant.
Tammie, thanks so much for the super chat. The West Memphis 3, Roberta, do you know how much the attorneys were paid? Well, I do know how much the innocence fraud campaign was put into freeing them, which is $10 to $20 million is estimated to free them, was put into freeing the West Memphis 3. And some of that had to go to, but that's everything. Experts, attorneys, $10 to $20 million was spent to, and the best they could do was get them out on an Alford plea. They were going to get a new trial, and instead they said, no, we'll plead guilty, which is legally a guilty plea, an Alford plea, but you can maintain your innocence. Michael Peterson took the same thing. Kathleen Peterson's killer. Staircase, known for the Staircase documentary. So it's big money is put into these innocence fraud campaigns. And we've seen the kind of money raised for Free Karen Reed. But the West Memphis 3 campaign went on for years and years and years. We had three or four documentaries. I think 4 altogether now. One produced by the convicted killer himself, Damien Eccles. So I was totally fooled by them. I was totally shocked that the record was so different than the documentaries and the evidence. It really does not tell the whole story. You can listen to my episodes about that. For those who have only seen the documentaries will go, oh, whoa, what are you talking about? You must be crazy. Check out the episodes I've done on the West Memphis 3.
I'm in fear every day of the defendant. I am very scared about potential future physical risk as well. To begin, the order was violated in February of 2024 during a hearing actually across the street at the Superior Court, which I and the attendant both attended. He did leave the courtroom, but he remained outside afterwards and essentially followed me to my car, taking pictures and videos of me as I walked with the group of people I was with, well within the 100 yards of the order. And I had no way to get to my car other than passing by him. as he moved from spot to spot, following me all the way to my car to the entrance to the parking lot. My car was vandalized that day.
Hold on one second. Sir, are you a member of the media?
Your Honor.
Folks, quiet, please.
My opinion, all this, the litigation, is what is called DARVO, Deny, Attack, Reverse, Victim, Offender. So the acronym, this is according to Wikipedia, suggests the common steps involved are: the abuser denies the abuse ever took place. When confronted with evidence, the abuser then attacks the person that is being abused for attempting to hold the abuser accountable for their actions. And finally, the abuser claims that they were actually the victim in this situation, thus reversing the position of victim and offender, which is exactly what every innocence fraud campaign does, which is why they're so hostile to the victim's family members, often accusing them of being the real killer. As we saw with the West Memphis 3, they had first attacked one grieving stepfather before attacking another, before, strangely, this victim's stepfather, his resources changed quite a bit, and he changed his position. And Terry Hobbs, who was accused of the West Memphis 3's crime, the second stepfather, said that they were offering his ex-wife the world to support the West Memphis 3 and promising her all sorts of things. So this DARVO was devised, came up by Jennifer Freed. I think her name is actually pronounced Fried, who wrote about it in 1997. Her parents started the False Memory Syndrome Foundation, which, after she accused her father of abuse, and she's been an outspoken academic for victims ever since. But that's her acronym, Jennifer Fried's.
Not today. Not that I know.
Are you going to have to put that video camera away? You did not request permission prior to the hearing. All right, you may proceed.
Thank you.
So the defendant was charged with a violation that is still a pending matter. It still has not been, we haven't gone to trial for that yet. So that is one of the reasons. Another, he was indicted for witness intimidation and wiretapping against me, and those matters are still pending as well at the Superior Court. We have not gone to trial for those either. And I'm very much in fear of what he may do in regards to the result of the cases, because he's also facing numerous other charges against many other witnesses and facing many, many years in prison. So I am very scared of what him getting in a desperate state, what he may do to try to prevent me from speaking, as he's already tried to do in the past. You know, he has expressed to me in the past and on his, so I should mention, I think it was in my original affidavit, he is a well-known blogger and YouTuber and has a very large following of fans. He gets tens of thousands, hundreds of thousands of views on his YouTube page and social media platforms. He has announced to me and on his YouTube shows in the past that he struggles with mental health issues. He has told me specifically that hears voices, has thoughts of suicide, that like he has suffered with this in the past, and I'm afraid what he might do if he was put in a desperate position facing all these years in prison. He has engaged in a year-long smear campaign against me, using his platforms publicly, even while he was in jail, writing blogs about me filled with disparaging lies from jail, posting my picture, private court documents. He posted police reports where he doxed my full name, address, phone number, birth date, and that has resulted in his followers, like he has like incited them to harass me as well. They've gotten death threats. I've gotten calls to the Board of Nursing to try to get my nursing license suspended, calls to my children's school and emails to their school, constant calls to DCF with false reports. May I look at my notes? Just, he was given by accident in April of 2024 a full forensic unredacted copy of my cell phone, which I had given to the Mass State Police because I was a witness for a matter that he was involved in prior to me. And it was handed to him by mistake, and he has been sharing it, announced on his show. Like, I was alerted to this by a friend back when it happened in April. He went live on his YouTube show and announced that he'd received this copy of my 15 years of my life, everything you could imagine, from medical records to attorney communications, picture, intimate pictures, everything, medical, bank records, everything. And he announced that he had already shared it with dozens and dozens of people, and he has continued to share information from my phone since that day that he got it, despite numerous protective orders with the courts at the Superior Court, and despite assurances from his attorney that he would not do so anymore. Recently, Judge Krupp at the Superior Court put in place a more stringent protective order, basically ordering him to give back the phone extraction and any and all copies, and stop sharing any information from my phone. But the damage has been done. He, mere days later after that order was put in place, he went on his show again and announced that the order was...
WD40 says, Roberta Glass, True Crime Report. Can you take his pics down? Sorry, it's attached to the video. Turtleboy makes me sick, so I put up my picture of my cat over him. How's that work? WD40. Is that good?
Was essentially useless because he shared it with so many people he can't even remember how many people he shared it with. And who's to stop somebody from an anonymous account or another country from sharing information? On one of his shows, he declared that when his trial is all over, he'll release the really good stuff. He has told his viewers that I conspired with the Mass State Police and Norfolk County District Attorney's Office to set him up, that this was all a big setup, and that nothing related to the charges ever happened, that it was all lies. And he refers to me and asked his viewers to refer to me as fake victim. So it has resulted in harassment from all of his fans everywhere. Like, I can't even come into the courthouse without being harassed on my way in, because he's convinced these people that I have lied about abuse, that I've lied about these allegations, and that I'm a fake victim. I received a disturbing phone call in...
You can just hear the upset. So this is an upset that I talked about when I was talking about Wendy Adelson. That's really hard to fake. You can fake it for maybe a minute, but where your voice is uneven, and Wendy Adelson tended to do this, but this is when you're really upset. You can hear the tremor in your voice, and you can fake it for maybe a little bit, but you can't fake it for the long time period in which LG is talking through this hearing. Thanks, WD40, for the super sticker.
I think it was
Appreciate it.
The August of 2024, from a number I didn't recognize, and I answered it, and it was late at night, and it was it sounded like a voice changer the voice sounded robotic, and they asked me where my daughter was and named her. She's 3 years old, and they said that they had a present for her, and then they started singing Ring Around the Rosie and hung up the phone. And I was later informed that the phone number is a number registered to Mr. Kearney. And
how did you learn that?
A friend alerted me, because I told a friend that I got this call, and I shared the number, and they Googled it, and it shows that the number is registered to him, and that I guess he has two numbers, and his main number is the one that I had, but this is his backup secondary number. So it shows, I submitted evidence to Attorney Brito, which I can give to you as well. It shows the Google search returns his name and address as the owner of the phone.
Attorney Brito, you've seen that. I have you on.
So the whole packet, it's the first 3 pages.
Judge, just for the record, I would object to any evidence that doesn't is material or relevant to the plaintiff's reasonable fear of imminent serious bodily harm. This is a 209A order. There's no right to get a restraining order out of fear of being disparaged online. So to the extent that anything in there just refers to disparagement or complaining about someone's conduct, I would object. Thank you.
Thank you. I haven't made my ruling yet. Let me read the material and I'll let you know what my ruling is. Plaintiff and counsel on that.
Once again, all phones should be turned off, okay?
It's really before me at the moment. You provided me with a packet of material, but what you're at least initially trying to move in is the phone number check. Is that correct?
Correct.
Okay. And I've heard your testimony regarding that. This phone number check is not authenticated. It's not a phone record, but I have heard your testimony on it. So as far as the phone record check, that will mark that A for identification, but that will not be permitted into evidence. So
Yes,
counsel, your objection is sustained. Do you want to move these other items in as well?
Yes, Your Honor. I've only provided just a few examples of some posts on social media and blogs that he has put up regarding me. These are, when I say only a few, I mean, he does 3 YouTube shows a week that are at least 3 hours long each and has been talking about me daily for the past year. So, and then has multiple social media platforms where he's posted about me hundreds of times, if not thousands. So I couldn't possibly submit everything to you. These are just a few examples. And I do want to say that the phone call, if that, I don't know if that specifically is what Attorney Bradel was referring to in the evidence I submitted, but it does directly relate to my fear of physical harm of the plaintiff. I took my children immediately the next morning, packed our bags and left our home because I was too scared to stay there. We went down to a private resort on the Cape, and when we left several days later, there was pictures posted on social media of my children and I on the beach. I can't leave my home without being harassed by his followers.
1 second, ma'am. I just want to rule appropriately on your evidence. So I have another packet of items that appear to be emails from Aidan Kearney, the defendant, or I should say postings by Aidan Kearney, the defendant, referencing you. There's a packet of them. Totals 11 pages. Again, counsel, I heard your objection to all of these items. As far as these items go, is there anything else you'd like to add?
Judge, just that there's they lack materiality in the sense that there's nothing germane to the standard that we're here to evaluate.
Okay. Right. So these items, collectively 11 pages, are admissible as exhibit number 1. So
Thank you,
those will
Hannah.
come in.
And exhibit 1.
And then there was an additional item or series of documents that were posts from other individuals, not Aidan Kearney. And those remaining items, the objection is sustained regarding those items. And those will not come in, those will be marked.
I thought the judge was pretty fair in this hearing. I don't know. Let me know what you think.
Exhibit B for identification.
Thank you.
This is the problem is that I believe LG went into this hearing thinking, well, the truth will win out. She needed to make a timeline out of everything and save every piece of evidence and keep a journal of every bit of abuse and harassment, or go back in time and create a timeline and recreate that. So if you are ever the victim of anything that you want to prove in court, keep a journal, keep a timeline, or recreate a timeline, get the receipts, as the young people say, get the proof, take screenshots, take everything. And so when Aidan Kearney came and showed his, that's what he's going to be doing, since he's got a master class in innocence fraud. So that was more persuasive than LG's own words. So as well as she comes off, as credible as she is, it wasn't enough when you're talking about limiting people's movements. And let me just say, from being trained by Gavin de Becker, the way that they saw restraining orders, they found that they were really limited in use and often inflamed the abuser and were not helpful to victims. I understand in a lot of situations, the best thing you can do is let your abuser know and then go no contact, how you feel that you want no contact and then go no contact.
You may continue.
So, even with so there was a modification to the order in April 2024, which allowed the defendant to be within 50 yards of me of any courthouse in Massachusetts. And even with just that slight modification, it's allowed the defendant the ability to abuse it and harass me. On one occasion, he sent one of his fans into the courtroom to take a picture of me at a probate matter regarding my children, and posted it from one of his they call it a stock account, like an account, like a fake Twitter account, basically. On another occasion, just recently, about 2 weeks ago on Christmas Eve.
Let me ask you a quick question about that. How do you know that you sent the individual, and did that individual tell you, or did you learn from some other source?
She told somebody that told somebody that he sent, so it would be hearsay, but she was there with the father of my children, who the defendant has publicly stated on his YouTube shows that he reached out to, who I have a restraining order against as well, after leaving a 6-year abusive relationship with him. And he has colluded with the father of my children to engage in more harassment against me.
Your Honor, suspicion is
If you still have more testimony, I'm happy to hear it, but that objection is sustained.
So recently, as 2 weeks ago, December 24th, I was in court for another matter, completely unrelated to the defendant, and he attended, I believe, just as a way to intimidate me, and sat in the back of the courtroom, looked over at me and smiled and winked. And
When was that?
What was that?
When was that?
December 24th, just a couple weeks ago.
Okay.
He had no reason to be at that court matter, and he announced on his show, actually, that he was not there as a reporter. And so I feel as though he's using this slight modification just as a way to continue to keep tabs on me and follow me to places where I'm going.
objection, Your Honor. That assumes facts, not evidence. She's never been followed.
Anything else, ma'am?
Each and every time, even like we just have a hearing like today, he obtains a video.
Right. So what this does is this constant harassment is make you very security conscious. Everyone I know who's been harassed by a cult, whether they've left a cult or been harassed by a cult, they tape everything. They tape their phone calls. They're very security conscious. This is what surviving this kind of harassment does to you, in my opinion. This is Karen Reed's text message that was leaked from March 3rd, 2024, when we know that the state was trying to get her on witness harassment charges. Aidan is a risk. I have been so careful to lay low, and he blows it all up. Last month, they took my phone, and that I've had for 2 years. It had tons of stuff on it, and that's all from the LG mess. I can't expose myself to that anymore. Lindsay mess. So was Karen Reed helping? I know they were having long talks on that encrypted app around that time. How was she involved in this is my question.
Audio and posts it on his YouTube show and sits and harasses. And I mean, he's made threats. He's told me on his YouTube show, he's talked directly to me at certain points, which I reported to the Medfield police. They did not violate him for that. But he has said that I'm going to get mine. He has said that like karma always comes around. She better watch out. He has, the day that he violated the restraining order, I think it was that morning, I later saw a clip of his show where he said that, you know, it wouldn't be smart of her to show up here. She better not, you know, something along the lines of like, you guys know what will happen. And he blows this dog whistle with his fans. And I'm terrified every day. Like I'm afraid to leave my house. I don't know what he's capable of and what he could or would do. There has been other people that have tried to get orders on him that were not successful in getting orders, and then
Objection to relevance on our motions.
well, and then he has showed up to where they work and live and tried to harass them. So I am extremely fearful that if this order is not renewed, he will use that same opportunity with me and show up to my children's schools, to my home, to where I am. And he says in his affidavit that the order prevents him from being able to travel freely and has something about his First Amendment rights, and that is completely false. I live in Medfield. I live nowhere near him. He has no reason to travel to my town. I don't go to anywhere that he goes. I don't want anything to do with him. I just want to be left alone. And I'm extremely fearful of what he might do, and if this order doesn't get renewed, I'm very, very scared about the lengths he will go to get revenge on me, as he has stated he will not go back to jail under any circumstances. And so respectfully, Honor, I ask that this order be renewed for as long as possible, for at least a year. But
thank you very much, ma'am. One question though. You said you were afraid that he'll go to your children's school. Has he ever gone to your children's school?
No, Your Honor, but he's their school has received.
So that's her weak point. They know that's her weak point as a mama bear protecting her kids. And this is where you show he's brought up my kids here, here, and here, and here, and here. You really need to have the receipts with you when you do something like this and protect yourself and be able to prove everything that you're saying. Your word isn't enough. And that's what thinking like a lawyer is getting your own evidence. And that's something that I've talked about Karen Reed being really good at, is fabricating her own evidence. So going to people's Facebook pages and getting pictures of them and statements made by them so that she can further her own innocence narrative. I don't think it's backing up the truth. She's, in my opinion, creating a fantastical narrative created from her head. But she's very aware of the evidence that she leaves behind. And that's something that I would encourage LG to do. Think like a lawyer. Document everything. Document everything. And keep it in a really organized way that's accessible, and you can have it. And so you're aware of everything that you have, and that you can bring it to hearings like this and to defend yourself in future lawsuits by Aidan Kearney for $2 million.
Numerous calls and emails from anonymous accounts with sexual text messages between me and the defendant that only he had, and references to his case.
From who?
It's from anonymous accounts.
All right. Thank you very much, ma'am. Counsel, do you have any questions for the plaintiff?
Yes, I do, Your Honor. Ma'am, that you said a couple of times here that you're scared of Mr. Kearney every single day. You're terrified. You seem like you're trembling. You're crying. You're having a rough time, right?
Yes.
On October 15th, 2024, you sent a tweet basically proclaiming that you're not scared of him, didn't you?
I'd have to see the tweet.
May I? You may. So my question to you, ma'am, is you sent that tweet, correct?
I'm sorry, I'm still reading. It doesn't say, I don't say that I'm.
There's no question before you, yeah, ma'am. Look up when you're done reading the
Okay.
text.
You've read the text?
Yes,
You sent that tweet, rather, right? You sent that tweet, correct?
I posted this.
You posted it. Thank you. I'll take that from you. Offer this judge as an exhibit.
I would object to the, there's no context.
So objecting to the context. Your objection is noted, but overruled. This will be entered as Exhibit 2.
Exhibit 2 entered.
Now, ma'am, you testified about a phone call that you say was made by Mr. Kearney from a 413 number on August 22nd, 2024, correct?
Correct.
And it sounds like a horrible incident. 46 seconds, taunting about presents for your kids, using a voice changer. It sounds really pretty evil and insidious, right?
Yes,
And so I presume that you called 911 after that?
I called the police.
And did you make a police report?
I did. They came to my home.
Do you have it?
Not,
Did you bring it to offer to the court?
no,
Ma'am, the fact is, this is a fake phone record, isn't that true?
no.
A fake phone record? They're thinking she made a fake phone record? Are you kidding me? What are we talking about? Just want to keep you updated on the give, send, go for the victim that we're listening to, the restraining order hearing. Lindsay Gattani. I guess I can say her name since I'm about to share it. But here, supporting Lindsay Gattani. And here, she's trying to raise $10,000. She's raised $3,026. Tam and Gizmo. Wonder who that is. It's Tammie and her fantastic cat Gizmo. We may not have met, but we are here for you forever. Just breathe, dear, and don't let anyone ever stop you from always going forward. And if you think in the past at times, train your brain to stop those thoughts and keep going forward. We all care deeply about you. Love from Indiana, Tam and Gizmo. Really nice. Thanks, Tammie. So the link is in the description of this episode. And it's also, I hope to pin it on the top of the chat. Maybe I'll do that now.
So you don't have any documentation of anything that you say happened here to offer the court today, correct?
I don't understand the question.
Just your word. You just have your word. You don't have any police reports. You don't have any recordings. You don't have anything, do you?
I didn't bring them, no.
Now, you also offered the court a stack of internet postings, some of which are from Mr. Kearney, some of which that were not admitted into evidence are from other people, right?
Correct.
Now, do you have a copy of your exhibit?
Yes, I do.
Can you look through there and just show me where there's any sort of threat to do bodily harm or property damage? Take all the time you need.
I don't think there's any threats about property damage in these.
What about bodily harm? Is there anything, I'm going to choke you, I'm going to get you, I'm going to beat you, I'm going to strangle you, I'm going to do anything to you, such as that?
No, not that I see.
Judge, I'd strike the exhibit for materiality relevance, given that this is a 209A order. There's nothing in there whatsoever beyond a general fear of disparagement, which I would contend is not sufficient.
It's still potentially relevant for coercion purposes, so your motion is strike is denied.
Thank you. Respect, Your Honor, only. Judge, just one moment, please, Your Honor. Now, the basis for this order a year ago was an incident that happened at your house on December 23rd of 2023, correct?
Correct.
And it's fair to say that the allegation of physical harm in that case was that you had taken some personal property of Mr. Kearney, some notes, stuffed them in your shirt or hid them in your mattress, depending on what document you consult that you wrote or caused to be written. And that in some sort of struggle to get those papers back, you fell down to the couch. Is that right?
No, that's not correct.
Well, isn't that what you told the police, that you were pushed down onto the couch?
I told the police that I was grabbed by the wrist and the arm and then pushed onto the couch. You just asked me if I fell onto the couch, and that's not correct. I did
All
not
right,
fall.
so you were pushed onto the couch by Mr. Kearney. That was the extent of the physical contact that was alleged by you, correct?
From that night, correct.
And that was the basis for the assault and battery charge that was brought, and that you then based your application for a restraining order on, correct?
That and the threats, the witness intimidation.
Threats and witness intimidation. But in terms of bodily harm, the only bodily harm that you've alleged is this being pushed on the couch allegation, right?
And also the grabbing of my arms, yes.
And you've since recanted that twice, haven't you?
No, I have
You
not.
said to Grace Barrett that it never happened. Isn't that right?
That's completely false.
And you also, do you know Mary Bagwell?
Yes, I do.
How do you know Mary Bagwell?
She used to be in a group chat that I was in with some other people who believed that Karen Reed was guilty.
Isn't it true that you told Mary Bagwell, your former friend, that getting pushed onto the couch by Mr. Kearney never happened? And when Miss Bagwell told you that you need to do the right thing and tell the truth, you said, no, you're stuck with it because the police are pressuring you and you can't take it back. Isn't that right?
Completely false.
Was that?
Yeah, you'll hear Mary Bagwell testify, and I did not believe her testimony. I didn't find her a believable witness at all. And the fact that Bradle's going on her word like it's gospel, meaning Aidan Kearney's lawyer, Timothy Bradle's going on Mary Bagwell's testimony like gospel, I find that unbelievable.
Before or after you threatened to murder her and her children?
I just told you that was false.
Did you threaten to murder her and her children?
Your Honor, I would object because this has no relevancy to this case.
Objection is overruled. Please answer the question.
Your Honor, I'd like to, this is a pending matter, so I don't know if I have a privilege here, a Fifth Amendment privilege to invoke. Mr. Kearney claimed in his affidavit that I am going to be getting criminal charges against me, but I have not received anything yet, so.
So what we'll do is I'll step this matter back. I'll give you an opportunity I'll appoint an attorney. I'll give you an opportunity to speak with that attorney. And then we'll proceed accordingly after I hear from the attorney.
For the call. Thank you. For the call.
Thank you very much.
Court, all rise. This court stands.
See, this is very fast thinking on Lindsay's part here to get a lawyer. So they push, they will push and push and push till you break, and you do something stupid. They're waiting for you to do something stupid like this. And I'll call it stupid. I think Lindsay would agree with me. And they wait for you to do something stupid like this. And then it's the perfect opportunity to say, see, she's really the abuser here. See what she did to Mary Bagwell, threatening her kids, et cetera, et cetera, et cetera. Her and her kids. I mean, do not think for a minute that she has not been profiled by these people. They know where to go. They know that the issue with her is her safety, her kid's safety. When she feels threatened, she will be mama bear and bite back. And you just have to work against those instincts if you're someone like Lindsay. Thank you, WD40. I appreciate it. Donated to Lindsay. Appreciate it. She also, it's not just the fact that she needs money for lawyers in the real world. That is a very real need. But just to show that she does have real supporters out there who do support her. It's a really important. I mean, also what these kind of campaigns do is make you feel very alone and isolated. And they take away totally, and this is what cults do as well, take away your ability to trust another human being. And that is something that most people take for granted, that they can surmise who is trustworthy and who isn't. But after something like this, remember, she was in a relationship with Aidan Kearney. She totally believed the free Karen Reed nonsense and had no idea what he was capable of.
Thank you.
What's that?
Okay, so she's got Mary Bagwell and Aidan Kearney.
Yes.
Okay. Struck a friendship with one of our witnesses today, Ms. Mary Bagwell, and they had a commonality surrounding the Karen Reed murder trial across the street, wherein they were both sort of anti-Karen Reed, pro-conviction protesters. So in other words, just
Anti-Karen Reed. It's like, it's not that we object to what Karen Reed did. We're just anti her. We're not anti-killer. Anti-cop killer. Pro-justice for cop killers. We just don't like the look of Karen Reed's face. And the other thing that they like to say is we're so jealous of her. We're all so jealous of her. We just can't stand it. All you women are just so jealous of Karen Reed. We can't stand it. It's ridiculous. We're just anti-Karen Reed. Anti-Karen Reed. I mean, if Karen Reed got I don't know what, some small citation for jaywalking, I don't think there'd be protesters out there. It's not that we object to Karen Reed. We object to her behavior and and ending the life of John O'Keefe, which there is a mountain of evidence against her. Should we go over it?
just for clarity's sake, taking a position opposite of my client. So Ms. Bagwell is on the other side, so to speak, on that case. She's not someone that's any sort of follower or puppet or anything on our side of anything. And they struck up a friendship. And
So here's where she commits. When she comes in, she'll commit perjury. Lindsay asked her, "You said Turtleboy loves you." And she said, "No, I never said that." She said, "Aidan loves me." It's on tape. We'll play it. But she's friends with Aidan Kearney's girlfriend, Meredith O'Neill. She says, I don't know that's her, Mary Bagwell's. And Aidan loves her, of course, because she's useful to him now. He can use her as a flying monkey. She was asked to call up. So what happened was she was asked to call up on this show and disparaged Lindsay, told these stories that Lindsay's kids almost drowned 3 times and had to be saved in the pool party. And it's very suspect that she uses the number 3, which is the liar's number. When people lie, they tend to use the number 3. It's not once, not twice, not 4 times, 3 times. Her kids almost drowned. And there are people who were there who say, no, this never happened.
Bagwell took issue with some things that Ms. Kearney did with her children, driving while intoxicated with her children, and talked about that. And in the course of that friendship, Ms. Kearney, this is our offer of proof that Ms. Bagwell will testify to. That
that's not what I'm asking. What I'm asking
sorry.
is for an offer of proof regarding what you believe the plaintiff's response
Oh,
would have been.
a truthful response, Judge, would be that she called Ms. Bagwell, and I'll give you the background later. I'm sorry, I didn't quite understand your question. She called Ms. Bagwell and threatened to murder her and her children. And I have a tape recording of it that I would offer as well. And I'd like to play that as a part of my offer of proof, if I may.
I would like to object to that, Your Honor.
Well, it's being played as an offer of proof at this point. Your objection is noted.
She should have come with every clip that Aidan ever talked about her every night. And it's hard because you want to live your life and you want to forget about it and not have to have this consume your life. But when it comes to these things, you need those things as proof. And what's sad is that she doesn't even trust anyone at this point to really help her. She maybe make those kind of clips for her, but she needs clips, receipts. She needs to bring all those things and a full timeline. Timeline's really important.
I'm not accepting it as evidence. Just permitting him to make a record regarding testimony that thus far I have not required him to respond regarding.
May I just make a comment? Because the recording was taken without my knowledge, and I don't know the relevancy as well. So.
Well, thank you for that. You may continue with your offer of proof. Thank you.
You are crying about my kids on an internet chat on the internet. Crying about your kids, Lindsay. Everything was true that I said. You stupid bitch. You need to stop drinking. Sweetheart, you want to stop drinking? You can't fucking stop. I will come to your house and I'll murder you and your kids. You understand me? You dumb bitch.
So Ms. Bagwell, we intend to call her to authenticate that tape and testify that that's Ms. Kearney. So it's the third, if not more than the third time that Ms. Bagwell was threatened by Ms. Kearney, resulting in Ms. Bagwell going to the Attleboro District Court and obtaining an order of a criminal harassment order, Your Honor, against Ms. Kearney, which is pending. And there's also an upcoming criminal complaint for threats against Ms. Kearney.
Okay. So your offer of proof is noted, and again, has not coming in as evidence at this time. Madam Plaintiff, counsel, you may continue your inquiry regarding cross-examination.
Thank you, Judge. And this certainly isn't, Your Honor is the fact finder, and I'm not looking for a response to this, but I would invite the court as the fact finder to make a negative inference due to the invocation of the Fifth Amendment privilege in a civil matter.
Okay, I am not going to do that, so your request is denied. But I'll certainly hear any testimony, and I'll certainly hear any arguments later regarding the admissible evidence.
Thank you very much, Ron. So, Ms. Catani, you know Mary Bagwell, correct?
Correct.
And how did you meet Ms. Bagwell?
I met her at a protest at Karen Reed trial.
And you got to be very friendly with her, correct?
Yeah, I'd say we were cordial.
You shared your domestic violence history, and she shared her history as well. Is that right?
I didn't share much of my history with him.
You met her about June of 2024. Is that right?
I would say so.
So why is Bradel trying to say that Lindsay shared her history, her DV history, with Mary Bagwell, and Mary Bagwell, what they're trying to insinuate here is that being a DV victim is a identity for Lindsay, and that it gives her something to relate with other women and to bond with other women over. And it's a way that she relates to people in the world, and it helps her bond with women. It's kind of, I think, a little ridiculous, but that's what he's saying. You shared your history, she shared it with you, and then you became very close. And Lindsay's like, no, we became cordial. Cordial.
On that date, on actually June 1st, 2024, you also were protesting with Ms. Bagwell at the Karen Reed case, correct?
I don't remember the exact date.
So it's fair to say on a couple of occasions you were with Ms. Bagwell when the Karen Reed case was going on across the street, correct?
I believe it was twice, yes.
And one time you saw Mr. Kearney in the vicinity in June, correct?
Also, Bradel's trying to insinuate that Lindsay doesn't care about John O'Keefe or Karen Reed. She just cares about hurting Turtleboy's business and his, and it's a way for her to stay constantly in connection with Turtleboy. So if she was protesting, it was really about Turtleboy. It wasn't about Karen Reed. That's also what they're trying to insinuate here. Just FYI.
No.
Well, you spoke with Ms. Bagwell about allegedly Aidan showing up. Isn't that right?
Yes.
And that's about the time when you were very angry that the state police had provided your phone extraction to the defense in the criminal matters that you're involved with regarding Mr. Kearney, right?
I believe that was several months later.
Thank you, Marianne, for donating. I donated, wish I had more Social Security, and my part-time job do not go far. I appreciate it, Marianne. Really appreciate it. And I'm sure Lindsay does too.
Well, you were mad that you felt like you were lied to by the police, that only parts of your phone were going to go to the defense, but the entire phone went to the defense, right?
Correct.
And you said to Ms. Bagwell that if you had known that, you would have never agreed to cooperate with them and give them your phone, right?
I said I would have never given my phone. I didn't say I wouldn't have cooperated.
And Mary Bagwell was trying to be sympathetic. She said to you that she was sorry that you were going through this, but don't worry, everything's going to be okay, right?
I don't recall what her responses were.
And you got upset. You said, no, it won't be okay. My kid's birth records, school records, doctor contacts are all stuff he now has. You said that to Mary, right?
I don't recall this conversation.
So back to Ms. Bagwell. You related part of that night to Ms. Bagwell, didn't you?
Attorney Bradel, I've told you
Yes or no?
multiple times I never had this conversation with Mary Bagwell.
You told Mary Bagwell that Aidan Kearney did not push you on the couch or assault you. Isn't that correct?
Did not. No, that is not correct.
You said to Mary that he was just grabbing at the papers. Isn't that right? Mary told you to do the right.
Wow. Now we don't have to wonder why Aidan, quote unquote, loves Mary Bagwell. Boy, she's proved herself to be useful. She said nothing at all, that he just grabbed at the papers. She said that you told her that he did absolutely, was a perfect angel. Heisenberg, Roberta, I can't wait to see the grand finale when it's Karen Reed versus Turtleboy. I'll get out the popcorn emoji. You think it will be? You think it will be? Curious if that'll ever happen.
Right thing and tell the truth, didn't you? You were screaming and crying at her. She felt bad for you and gave you a tissue, didn't she?
No, it's never happened.
You felt badly for what you did, and you expressed that to Ms. Bagwell, didn't you?
Nope, I never did.
So just imagine yourself in Lindsay's position. You're having this attorney. This is my point of view, obviously. State things that you know didn't happen. So you're getting more frustrated. So this works on two levels, this kind of cross-examination. This person said this. This person said this. This person said this. So you're getting more and more frustrated with the attorney, which makes you put up your feathers and get riled up and on edge. So it works on two levels. And of course, you don't have an attorney to object for you.
As July goes on, Ms. Bagwell expressed concerns to you about your parenting and your drinking, did she not?
No, she never did.
She never did. That was in the summer of 2024, wasn't it?
Never happened.
You started to get annoyed with Miss Bagwell. You started calling her a bitch, tell her to worry about her own fucking kids, and that she had better stop talking, and that she didn't know who she was fucking with, and that you said initially that I will come to your house and beat your ass in front of your kid. All right?
Stop. Do not answer that question. That was the Fifth Amendment issue, counsel. Do not go there.
In December of 2024, so just this past month, you called Ms. Bagwell 8 times from a blocked number, correct?
No,
Didn't you admit to the Attleboro court judge that you did so?
it was 4 times.
So you admitted to doing it 4 times? To the Attleboro judge?
Yes.
And Judge, just to point out, before Ms. Kearney answers, my next question would be, you also admitted to the North Attleboro judge that you called Ms. Bagwell and threatened to murder her and her children. Come to the house and murder her and her children. And that doesn't.
So I'm sure that Lindsay regrets this. I can't speak for her. I'm just assuming doing this. But do you see how now the entire cross-examination is about Lindsay's behavior and not anything about Aidan Kearney? Deny, attack, reverse, victim, offender. It's the name of the game here, and it is really the name of the game with innocence fraud campaigns. Make the victimizer the victim, and you got it made. And now the
Mission in the court record in Attleboro. That's my
I
question.
appreciate you presenting that to the court first. And you may not have that question, counsel, but you may proceed with your answer.
Thank you. And just in terms of an offer of proof, I would contend, Judge, that that's my information from my witness, and that I would make an offer of proof, and I'd make a legal argument, Judge, that Ms. Kearney has waived her Fifth Amendment privilege relative to this transaction by testifying to it in the Attleboro court. Just my legal argument.
Your offer of proof and your argument is noted, but overruled at this time insofar as being permitted to ask that question.
Thank you, Mr. Chairman.
what choice did she have? I'm not going to testify in Attleboro court. because I need my restraining order. Going,
Now, ma'am, you talked about the pending violation of a restraining order case in this court. You recall talking to the judge about that? Judge Clifford, here today?
The pending restraining order case with who?
With Mr. Kearney. You spoke to Judge Clifford about that today, correct?
Correct.
And that was on 2/26/24, correct?
I'm confused.
On 2/26/24, you were
The
at.
violation. I'm sorry, I didn't mean to.
That's okay. You were, all right, let's rewind a little bit. There's a pending violation of a restraining order case in this court, correct?
Yes, correct.
And that was on 2/26/24, resulting from you coming out of a Karen Reed murder case hearing, claiming that Mr. Kearney was violating the order against you, right?
Correct.
Remember you told Judge Clifford about that, right?
Yes.
You said something to the effect that you were concerned that you couldn't get to your car because he was sort of blocking the way, something to that effect, right?
Something that I was forced to walk past as he followed.
And you told the police that he was screaming at you, liar, liar, correct?
Yes.
And you implied or said to the police that you perceived that and experienced emotional distress from that and fear, right?
I don't remember what my exact words.
I'm not asking you for your words. I'm asking if you remember what your emotions were at the time. Fear and emotional distress, right?
After the hearing?
Yeah, when you said this thing happened.
Yes.
So isn't it true that you had no perception or realization that Mr. Kearney was anywhere near you when you came out of that courthouse?
No, that's not true.
That's not true. All right, let's go through it. So you get out of there. It was a quick hearing that day, right? It was about a 10-minute hearing and you were out of there at about 2:10 p.m., right?
Should I answer these questions where we still have not found a trial for this matter?
Ma'am, please answer the question.
Okay. Can you repeat it, please?
You got out of the Karen Reed case that day on 2/26/24 at about 2:10 or 2:15 p.m., right?
I don't remember the
You
time.
remember the day. It was a quick hearing,
I
right?
remember the day, but I don't remember the time.
You came into that courtroom and you were acting like as a human shield to kick Mr. Kearney out of there, weren't you?
No.
You stoked up a friendship with people that are antagonistic to him, and they brought you to court that day to kick Mr. Kearney out with that restraining order, right?
No.
Well, you walked into that courtroom at about 2 o'clock with the restraining order copy in your hand, didn't you?
I walked into the courthouse, and when I went through security, well, before I went in the courthouse, a member from the group called ahead to let them know there was a potential that
My question was that you went into the courtroom with the restraining order in your hand, correct?
I was told to have it out and ready. Yes.
So it's a yes.
Yes.
You went in there, you knew Mr. Kearney was already in there.
so again, he's saying that being I almost said I almost took his language. Being pro justice for John O'Keefe is actually gives her an identity. That's what he's saying. Being a victim, being protesting, standing up for the other side, the small minority other side, gives her an identity. And that's why she does it. And it lets her stay involved with Aidan Kearney.
Performing his job as
So they just want to, also, its point is to shut her up, too.
a journalist covering the Karen Reed trial, correct?
I didn't know.
You knew he was in there, didn't you?
I knew there was a potential he could be in there.
Mr. Kearney had publicly announced that he was going to the Karen Reed case that day, and you knew about it. Isn't that right?
No.
You went in there with the restraining order in your hand to flush Mr. Kearney out of that courtroom at the behest of all the people on the prosecution side of that case to exact revenge on Mr. Kearney. Isn't that right?
No, that's not right.
Mr. Kearney was in the room, wasn't he?
In the courtroom?
In the courtroom.
Yes.
He got up as soon as he saw you and he left, didn't he?
I believe he was asked to leave by one of the court officers.
Mr. Kearney left and went out of the courtroom, right?
He did.
The hearing was quick and you were leaving with a big group of people, right?
Yes.
You left the courthouse. There was a huge throng of people outside and everyone was dispersing as they will from a court hearing, right?
Yes.
You were with a group of people. You exited the Dedham Superior Court, the Norfolk Superior Court. You made a right and you went behind the registry building to go to your car, correct?
I made a right.
Walked across the street.
Yep, crossed over. And then, yes, went behind the registry.
And you were with a big group of people, weren't you?
Yes.
All right. And that's when you claimed that you hear Mr. Kearney yelling, liar, liar, and you see him and perceive him and experience emotional distress from him, right?
Yes.
And he's violating the restraining order, right?
Yes.
Then you go to the back of the registry building with a group of people and you go to your car, right?
Yes.
And you think that somebody did something to your car, right?
Somebody did do something to my car.
And you call the police because someone did something to your car, right?
Yes.
And
Well, I did not call the police. A member from the group I was with.
and Officer Kozak responded to a report about damage to a motor vehicle, right? From the Denton police.
I believe. I think that's what it was. Yeah.
And the time received was 14:32:06, so 2:32 p.m., right?
Sounds about right.
So he was there about 10 minutes after you got out of there, right?
If that's the time you have.
And you had just experienced a blatant violation of a restraining order from Mr. Kearney, calling you a liar, screaming at you, causing you upset, causing you to be in fear. That's your testimony, right?
Yes.
So you must have told Officer Kozak 10 minutes later that Mr. Kearney was in violation of your restraining order and that he should walk 5 minutes away and arrest him, right?
I told him about the violation. I didn't order him to do his job.
You told him about the violation.
Yes.
So Officer Kozak no doubt would have put that in his report, that you told him about a restraining order violation that just blatantly happened to you, not 5 minutes prior, 10 minutes prior to his response, right?
Oh, here we are with the reports, what they put in their reports. Anybody that sounds familiar, doesn't it? Anybody watch the first Karen Reed trial? Is it in these officers' reports? They hate writing these reports. Snow Remover, thanks for becoming a channel member. Appreciate it. Great emojis available. I got to put up more emojis too. Available to my channel members. Appreciate it.
I would have thought so.
I'd offer this judge Officer Kozak's report. Speaks for itself. And sorry, Judge. Let me know when you're ready, Judge.
All right, any objection to the same?
No.
Okay, so this item will come in as exhibit number 3.
Yes, Your Honor. Enter exhibit 3.
You may proceed, Attorney.
Thank you. So you didn't report it to Mr. Officer Kozak? He didn't put it in his report because that never happened, isn't that right?
I did report it to Officer Kozak, and it did happen.
Officer Kozak came in to the hearing that you participated in based on your story here to try to revoke Mr. Kearney's bail and send him back to jail when this happened, isn't that right? He testified right in front of you, didn't he?
I don't remember him testifying.
Officer Kozak came to that bail hearing and he testified that you said nothing about any restraining order violation 5 minutes prior by Mr. Kearney, didn't he?
I don't remember.
Judge, I have Officer Kozak's testimony. I don't have a separate copy of it, but I can either, I'm sorry, we actually have it on a flash drive. So I just would call your attention to that, invite your attention to that, if I may, as the fact finder, that you're going to have Officer Kozak's testimony from the prior hearing where Officer Kozak corroborates everything I just said about him and his own police report that Ms. Gattani said nothing about any restraining order violation 5 minutes prior. So I offer that. Now
that's not coming in, but I have the report and I have his narrative, which addresses that issue, and that has been entered as exhibit.
All right, thank you, Your Honor. I'll leave it at that. I can chat one moment, please, Your Honor. So, Ms. Gattani, you know that Mr. Kearney's profession is as a journalist to cover the Karen Reed case, right?
I wouldn't say that's his profession.
Well, you know that Mr. Kearney is covering the Karen Reed case and reporting on it prolifically. Isn't that fair to say?
Yes.
And so if you're afraid of him, you could just not go to the Karen Reed case where he works. Isn't that right?
I could.
But you don't, correct?
I went to the Karen Reed hearing.
When Mr. Kearney announces that he's going to be at the Karen Reed hearing cases, sorry, strike that. When Mr. Kearney announces that he's going to be at the Karen Read case hearings, you show up. When Mr. Kearney announces publicly on his Twitter feed or his Facebook that he's not going to.
Right. Why are you going to places where Aidan Kearney is? Why don't you just modify your life around where he is and just avoid him?
To go, you don't go. Isn't that right?
No.
And you only developed an interest in attending Karen Read hearings after you got a restraining order on him. Isn't that right?
No, that's not right.
You're trying to use the restraining order as a sword rather than a shield to try to get him in trouble with it, rather than use it as protection. Isn't that right?
No, that's not right.
So you just have an abiding interest in the Karen Read hearings and you want to go there all of your own accord?
I was interested in the case. That's how I met him.
You never went to a Karen Read hearing until you got the restraining order. Isn't that right?
I didn't go inside the court, but I went to a protest outside.
Sorry, just if I could just have one moment, please. Now, June 28th, you were at a Karen Read hearing and you gave a media interview, correct?
I don't recall.
You walked right up to a camera right near where Mr. Kearney was and you started talking to the media, didn't you?
No.
It's fair to say that on many occasions, you seek out Mr. Kearney, you try to tweak him, you try to go to where he is and cause some trouble. Isn't that a fair statement?
Absolutely not.
Right. It's Lindsay who's terrorizing Aidan Kearney. Doesn't everybody see it? She wants to attend a Karen Read protest or hearing.
So you just have an abiding personal interest in the Karen Read case that just coincidentally meshes with whenever Mr. Kearney is present covering the hearing?
No. I've only been to 2 Karen Read hearings and I went to 2 protests. And I never paid attention to if he was gone or what he was doing. And the 2 protests I went to were after that order was amended.
And you're also trying to keep the attention on you, keep the controversy going because you're trying to make money off it. Isn't that right?
No.
You have bragged about a big film deal that you're involved in where you're going to be played by someone and you're going to make money off of a film contract. Isn't that right?
That was a joke.
It was a joke.
Folks, quiet, please.
God, there are more documentaries and competing documentaries going on behind the scenes about Karen Read. Tammie, Nat, had she found Karen Read on had she not found Karen Read on Facebook, Turtleboy may not have met up with Karen Read, I think. If Natalie had not found Karen Read on Facebook, Turtleboy may not have met up with Karen Read, I think. I think you're right. Natalie hooked up Karen Read and Turtleboy. Natalie Bernschneider Wawiki. I believe that's right.
Now, in December of 23, it's fair to say that your relationship with Mr. Kearney had been winding down.
Yeah, we broke up in early December.
And you called him in a fit of rage around December 9th, saying that you were going to be his worst nightmare and that he didn't know who he was fucking with and that you were basically going to get him. Isn't that right?
Just for the record, what year is that?
23, Your Honor.
I don't recall. I don't remember ever making those exact statements.
And you claim that you were pregnant with his child, right?
Yes.
And you showed him pictures of some sort of medical pictures that you claimed were linked to your pregnancy with Mr. Kearney, correct?
Yes.
And in fact, those pictures, the metadata of those pictures showed that those pictures were a couple of years prior to any interaction with Mr. Kearney, weren't they?
That's what the metadata showed, yes.
And in December of 2023, you called Mr. Kearney on the phone using this pregnancy story, threatening to, quote, drop that fetal alcohol syndrome baby off at your house and party my fucking life away. You said that to him, didn't you?
When are you talking about?
On December 9th, 2023.
I don't recall the exact words I used.
You said that ending the relationship was going to be Mr. Kearney's, quote, biggest regret. You said it's going to be the biggest regret of your life to Mr. Kearney, right?
I don't remember.
And all of these machinations over the last year, reporting Investigator Chapetta to the police with nothing happening from it, reporting me to the Board of Bar Overseers with nothing happening from it, threatening to murder Mary Bagwell because of it. This is all part of your campaign to exact revenge on Mr. Kearney, isn't it?
Well, good for her for reporting Bradel to the bar. But these lawyers, when they go out of the rules of their profession, and I'm not talking about Bradel, I don't know about the specific allegations against Bradel. I'm just talking about lawyers in general. So often get never reported by anybody, and it goes on. And when they do get reported, they're in front of the bar and other lawyers are deciding their fate. So I don't know about this, it just seems like it's like we're in the Wild West with lawyers going way beyond the bounds or going up to the line, crossing the line, retreating back from it. I mean, if we've learned anything from the Karen Reed case, watching Yannetti in pretrial hearings say that use their own leaks that they've given Turtleboy, meaning from the mind of Karen Reed and her lawyers, they've given it to Turtleboy. He's written about it, and then they mention it in their own motions as it's been reported. But it wouldn't be reported if they hadn't leaked it. So you can't do that. So if Lindsay, and I believe she did believe that Bradel had stepped beyond the bounds of the rules of his profession and reported it, her, good for her. It's not done enough, in my opinion.
That correct?
Don't answer that question. Again, that goes into the Fifth Amendment issue, Attorney Bradel, you know that.
I'm sorry, just one moment, please.
So now the judge is having to be a lawyer for Lindsay Cattani. I mean, this is just back and forth and back and forth. And Bradel knows that if the judge doesn't object to it, no one's going to object to it, his questions.
Now, you claim that you want to get away from Mr. Kearney, right? You don't want to interact with him. You're afraid of him. You want to just get him out of your life, right?
Yes.
So if one were to print out all of the texts, all of the tweets, all of the references to Mr. Kearney, they would probably be about 3 inches thick, wouldn't they?
I've never contacted him, and my tweets began 6 months after he had been harassing me, and I started to tweet the truth out there because he was defaming me all on the internet. So you probably find a significant number of tweets from me, but I've never contacted him.
I'm just going to show you this pile. Take a look at that. Just leaf through that and tell me what. Tell me when.
Once again, quiet, please.
Tell me when you're done. And then I'm just going to ask you in general, what is that pile?
Most of these look like tweets from me responding to the lies that he's put out there about me.
All right, I'm just gonna retrieve that back from you, please. Thank you. So it's fair to say that there's a 3-inch thick, and I'm gonna spare the court the contents of this, Judge, and ask her to just describe that. It's a 3-inch thick pile of tweets criticizing him, needling him, provoking him, isn't it?
In response to probably a pile this high from him about me, yes.
That's your characterization, is what I would have said. That's your characterization of those tweets.
And you gave that pile, as you call it, to the court here today, right?
No.
So you don't have it then?
If I were to print out everything that he has written and said about me, it would take me years. He does 3 shows a week that are 3+ hours long each. He has Facebook, Twitter, every social media platform, posts about me daily for the past year.
And every
Talks
time,
about me daily
sorry, go
for
ahead,
the past year.
and every time he tries to
Unfortunately, that's what you have to do. Aidan Kearney's got Meredith. He's got all his flying monkeys to keep track on Lindsay, whatever she's doing. And unfortunately, she's got to be like a one-woman army. It's unfortunate, but if she wants a restraining order, and protect herself from ongoing the current litigation. Heisenberg, winning a case when the other person didn't have legal representation is not a win at all, in my opinion. Good. And in civil court, basically the equivalent. Wants to win in civil court, Aidan, the defamation thing. Hopefully she'll have a lawyer by then, but yeah. So, they just have to, it doesn't go deep with these lawyers. They don't have time. These judges, they don't have time. They have to make a snap decision. And that's why it's really important to bring everything with you. And I know I'm just like a broken record, but it's really
defend himself.
I think my boyfriend told me one time it's like a revelation early in our relationship. He's like, it's not what you do, it's how people perceive what you do. So it's important it's not enough to just say this, well, I was being harassed. You have to prove it. You have to have the receipts. You have to protect yourself and think like a lawyer.
You accuse him of something else, don't you?
No, that's false.
Now, you also contacted him on February 22nd, 2024 at 1:57 a.m., didn't you?
That's the only contact I've ever had that I've already explained in court under oath. That was an accidental call when I was printing out evidence for my grand jury testimony the following morning. He was still in jail, and I accidentally hit the button because I fell asleep while I was printing, screenshotting and printing evidence from my phone.
So you have to go through 3 different efforts to unblock someone to then call them, right?
I didn't have him blocked. I had him unfriended. I never had him blocked.
Isn't it true that the printout of this call has an option to unblock him, which suggests that you had him blocked? And I can show you that.
I already know. Yeah, I took the screenshot after because I blocked him immediately after I accidentally called him.
So this is a screenshot of your Facebook call to Mr. Kearney,
And that's
correct?
actually his screenshot. So that's his option to unblock me, which means he had me blocked.
As he should. I offer this judge as the next exhibit.
Folks, once again.
Then you also, I'm sorry.
That's okay. Any objection?
I objected the testimony about it. It's not correct what he's saying, but.
All right, thank you. This will be entered as exhibit number 4.
Exhibit 4, enter.
Ready, you may proceed.
And ma'am, you also called Mr. Kearney Thursday, March 7th at 3:52 p.m.
No, I did not.
You texted him rather, I'm sorry.
No, I did not.
You did not. Let me show you this document. Have you ever seen that before?
Yes, I saw it in court at one of the hearings.
And that's a text that you wrote to Mr. Kearney on that date, even though you had the restraining order, right?
Absolutely not. A text is not from me.
Well, it talks about things that only you would know, right? Like the fact that Mr. Kearney was arrested.
I don't know how that's something that only I would know. Everybody knew it was on the news.
Well, the message talks about his girlfriend Meredith. It talks about that he's going to jail, or he can live stream right now, apologize, and call yourself a little bitch. And you have 15 minutes to do so. Didn't you send that to Mr. Kearney?
No, I absolutely did not.
That sounds like someone else. On this side of the fence. But I know Meredith O'Neill is Aidan Kearney's girlfriend, and I know he was arrested. Great points on Lindsay's part. How are those things only she knows?
Because the text message also indicates that the police came and looked at your cell phone that day, and only you knew that. Isn't that right?
The police didn't come to look at my cell phone that day.
Hey, cops came up and asked to look at my phone and said you filed a complaint. So the text is in first person as if it's from you, right?
Wasn't me.
So you're saying that someone else just took it upon themselves to pretend to be you and address Mr. Kearney demanding an apology?
There's nowhere stating on that message that they're pretending to be me. You're alleging that it's me based on your own made up story. That's not, it wasn't for me. I didn't text him. I have not contacted him. I want nothing to do with him. I don't text him ever, and I never have.
Well, the 3 inches of needling that we just went through show that you do want to mess with him. You do want to engage with him. Isn't that right?
No, I want to defend myself against the disgusting lies that he keeps spreading about me on his platform that has hundreds of thousands of viewers. I don't have an outreach like that. So he has destroyed my life with his lies.
Now, back to Ms. Bagwell for a moment. She went to the Attleboro court and got an order on you, correct?
Right. Hold on. Let's get to Miss Bagwell just briefly. And let me just show you this so you just have a sense of who Miss Bagwell is before I go any further.
Ma'am, this is your opportunity. If you have any questions to this witness, you may inquire.
Stand up, please.
Isn't it true that you went on a talk show the night that you claimed that I called you and made threats to you?
So this is Lindsay cross-examining Mary Bagwell.
Not that night, I did not. It was the day before.
It wasn't that night?
It wasn't that night. That was December 9th. When you threatened to murder me and my kids, it was December 10th.
December 9th was the talk show.
Yes.
And you went on a talk show.
Yes.
And you called in.
I was asked to call in, yes.
You were asked to call in. By whom?
By the moderator and the hosts of the shows. They asked me to call in because you and your friends have been attacking me on Twitter for over 2 months. And I don't have a Twitter, and you knew that, and everyone knew that.
Do you realize that there is a recording of this entire show on YouTube?
Wait, so she doesn't have a Twitter, so she went on a talk show? So I believe this is the JFK live thing. I also played clips of that when people thought that it was a witness in the Karen Reed case calling in disguise. I've also played that clip.
Yes.
So you're stating under oath.
There's a recording of
So they thought it was Higgins.
what?
The show that you called into.
I mean, I haven't seen it. I just called into
But
it.
you're aware that it was recorded.
There
and
was,
published.
all I talked about was how my son saved your children 3 times from drowning because you were too drunk and too
I'm asking you if you're aware
intoxicated.
that it's published online.
I don't
Since
know
you're
if it's
claiming that
published
somebody asked you
online.
to call in.
I don't know if it's published online or
So
not.
you called into the show, and one of the first things you said was that you have been involved with the Karen Reed case, that you initially believed that she was guilty, that you no longer believe that, and that Turtleboy loves you. Did you not say
I
that?
did not say that.
So if we were to pull up the show
I would
and play it today, we would not hear you say that Turtleboy loves me.
Turtleboy loves me. I didn't know.
I'm friends with Meredith. And so
Meredith is
whoever this,
Turtleboy's girl, right?
yes, yes, yes. And Aidan knows about me. I've had conversations. I've had many conversations with Meredith. Aidan loves me. We're all good.
Aidan loves me. There you go. Perjury. Right there. I guess if you're a lawyer, you could say, I didn't say Turtleboy loves me. It was Aidan loves me, but it's essentially the same thing. And that would be hard to get around. So there she is committing perjury for her new, what is she, daddy. And he calls his group a sex cult. That's what he calls his group.
Correct.
She also is the complainant in a pending criminal complaint matter as well. Isn't that correct?
I don't know.
How long is the harassment prevention order against you in effect for?
1 year.
Do you have a date yet for the clerk's hearing as to the criminal complaint?
No.
That's all I have, Your Honor. Thank you very much.
All right. Dan, any other evidence you want the court to consider?
No, Your Honor.
Because you rest at this time?
Yes, I do.
Attorney Bradel, do you have any evidence you want the court to consider?
Judge, I'd ask that the court enter a required finding relative to the lack of reasonable fear of imminent bodily harm. As the court's aware, the plaintiff needs to establish anew that they have a pending current reasonable fear of imminent serious bodily harm. There's been nothing in the record other than a generalized fear of disparagement. And on the face of the record, as it stands, getting pushed to the couch over a year ago, wouldn't satisfy as a matter of law any sort of...
Matt Hurd says he loves her until he doesn't. Well, I don't think Turtleboy's capable of love, but that's my thought on it. I hope she didn't let him take any boudoir shots. Well, that's his thing, and unfortunately, that's all used. He likes those for two reasons. I think one, he's into them, and two, it also gives him tremendous power and possibilities for revenge. It's very much the way Karen Reed and Aidan Kearney are very much two peas in a pod. I consider them both psychopaths. And we're going to get into Mary Bagwell's testimony in a moment. But before we do, I'm going to just look at your comments from last episode where we were talking about Marie Russell, Dr. Marie Russell, and her absolute washout of a hearing. Let's get it.
We got you coming. You had something to say. You were insightful. Oh, so clever. So Roberta's going to read your comments. Hey, Roberta, read those comments.
Okay. Lee says, I agree with what you said, Roberta, about the expert comment. You can't testify as an expert unless qualified by someone, usually boards and fellowships. She's an emergency medicine expert and could testify as a lay person. Those things help. It's really the judge when you're questioned like this. who decides if you can be qualified as an expert. She's an emergency medicine expert and could testify as a lay person if defense wanted. If she doesn't get approval for being an expert, experts have specific methodologies and procedures that are accepted among all the people in the same group of experts. I'm sure the dog warden has seen many bites, but he's not an expert on them. Karen Reed's side makes people think experts on a specific topic can just spew any BS on the stand and it's okay. Correct. You have to say how you did it. You can't say why I determined that they were dog bites just because it looks like, and I've seen a ton of them. Well, what specifically looks like them? And when she got into the specific wounds, the teeth were backwards. That doesn't surprise me. That's to be expected. I mean, it was a nightmare. A nightmare. Hotel California, 1963 says, I don't see how the defense would want this expert to testify before a jury. At this point, the prosecutor will make mashed potatoes out of her and the dog bite theory. Great show. Thanks. M. Skate 8386 says Karen Reed is rude. Attorneys have no control over her. They don't care about decorum in the courtroom. They just want to get through this and get the money. True. Rosie Grace says, I'm reading The Sociopath Next Door by Martha Stout. Describes Karen Reed very accurately. I wonder when that word sociopath began to replace psychopath. I'm so curious. All right, let's get on to Mary Bagwell's testimony. And then I think we will, we've been going for almost 2 hours. I think we'll end this show after that, but just so you can hear some of her testimony.
Incident that would validate if.
Let me just move forward. Here we go.
Currently, almost every
person sitting at the along. It was the Karen Reed murder case, and you would protest in favor of kind of the prosecution position. Is that right?
Yes.
Okay. And so just so we're fair, it's not a.
Wait, hold on. I'm sorry.
And so that's a factual issue. But in terms of we'll do it if the court doesn't rule in our favor on this. But the state of the plaintiff's evidence, before we go any further, is that she has a fear of disparagement. And, it sort of reminds me of O'Brien v. Borowski, Your Honor. Fear of being sued or fear of being disparaged is not a fear that can overcome the Constitution. It's not a fear that is lawfully recognized, especially in the 209A context, where the standard is reasonable fear of imminent serious bodily harm. So I would ask the court to enter a required finding against the plaintiff.
Which is not a typical motion in a restraining order. I'm going to make my conclusions after I've heard all the evidence. The motion for required finding is denied.
I appreciate it, Your Honor. I'd call Mary Bagwell, please.
step off.
And I think she's just right outside the door.
Sure.
Yes.
Mary Bagwell?
Calling Mary Bagwell. Calling Mary Bagwell. Can you imagine if they did that? Name sounds sketchy, says Tammie. Funny.
Do you swear in the matter now in hearing to tell the truth, the whole truth, and nothing but the truth to help you God?
I do.
You may sit or stand, whichever is more comfortable for you. Please keep your voice raised for the record.
May I inquire? Thank you. Hi, Ms. Bagwell.
I'm surprised that lightning just didn't strike her right there. She took the oath.
Hi.
Please state your name and spell your last name.
Mary Bagwell, Bagwell.
And do you live in the town of Mansfield?
Yes, I do.
Are you pretty much a lifelong resident of Mansfield?
Yes.
Do you have a family?
Yes.
And who are they?
I have two sons, Jacob, he's 17, and Aaron, he's 29.
All right. And you're in the finance and accounting industry?
Yes, I am.
And you work for a government contractor here in Massachusetts?
Yes, I've been there for 24 years.
All right. And you're a single mother of the boys?
Yes, I am.
Do you know the person sitting at the desk right in front of you here?
Yes, I do.
And who is that?
Lindsay Catani.
How do you know her?
We,
Just in general.
we used to be friends.
And when did you first meet her, just in general?
April of around the springtime of 2024.
And what was the context of meeting the plaintiff?
We did protests together.
And that was just to kind of move it along. It was the Karen Reed murder case, and you would protest in favor of kind of the prosecution position. Is that right?
Yes.
Okay. And so just so we're fair, it's not a position that was shared by Mr. Kearney, to your knowledge, right?
No, it was not.
Okay. And what were the kind of what was the nature of your relationship with Ms. Gattani, and how did it develop in a nutshell?
We started talking on the phone through a mutual friend. She would call us on a three-way call. After a couple of calls, then we all created they created a group chat in the Messenger app, and from there we would frequently, almost every day, we would all be either audio calling or video calling each other. So we regularly stayed in contact.
Okay. And with respect to strike that, you're aware of the criminal case that Ms. Gattani is involved in, where Mr. Kearney is charged with violating a restraining order, right?
Yes, I am.
And you're familiar with the case where Mr. Kearney is accused of being at her house on the 23rd of December of 23, and some sort of altercation happened. Is that right?
Yes.
And so you were aware of these things when you were friends with
the little baby voice testifying. That's always a red flag. When it's the little baby voice.
Ms. Gattani?
Yes.
Did Ms. Gattani have a conversation with you in the summer of 2024 about the true events that happened at her house on December 23rd
Yes.
of 23? What was the conversation?
She had told me that Aidan had taken notes from her phone, and he wrote them down in a notebook. When Aidan wasn't looking, she said that she ripped the pages out of the notebook and shoved them down her shirt. Aidan went to get his notes and noticed they were gone. He asked Ms. Gattani where the notes were, and can you give them back to me, please? And from there, she ran into the bathroom, locked the door, and called Ken Mello. And she said that Ken, he didn't answer. And that she had also stated that he didn't push her on the couch or assault her. He was just grabbing at the papers. He was trying to get his papers back.
So I've heard Aidan's version of this, and I am just going to regurgitate it under oath. I wasn't really there.
Did she strike that? Did you say anything to her about what you thought she should do in light of what she had told you?
I said, you need to tell the truth. And she said, I can't, because I have to stick with what I've already said.
Was there anything else, if you can recall, about that particular conversation about
I say this never happened, just my opinion. I can't know because I wasn't there. But just by the way this is going.
the incident involving Mr. Kearney?
She just felt very bad of what she did. She seemed to be struggling.
Yes, Judge, she seemed to be struggling. She struggled.
Did she ever, to your knowledge, act on feeling bad about it, or did she return to pressing that position?
Did she what? I'm sorry.
Did she act on that? Did she, to your knowledge, did she go to the police and explain it? Did she put out a tweet recanting it?
No.
To your knowledge?
No.
Did she return to the prior position that?
Well, she just said she wasn't on Twitter, or later she said she's not on Twitter. How would she know?
No, because she's a monster. She's a terrible monster. So she didn't even feel bad.
That's what happened?
Yes.
So you're really going to tell all this to an acquaintance? Come on.
Now,
that's why it was so important to Bradel to say they were really close. Of course, Aidan Kearney loves her. He's weaponized her against Lindsay.
As your relationship with Ms. Gattani evolved, is it fair to say that the relationship got somewhat antagonistic?
Yes.
And tell us about that. What happened with respect to Ms. Gattani and the way that she treated you, just in a nutshell?
I was just trying to help her get help with her drinking. There was an incident on June 18th, 2024.
Well, let me just stop you there. I don't want to go through a whole litany of things.
Okay.
But is it fair to say that you wrote an affidavit and signed it and provided it to the defense today?
Yes.
All right. And Judge, I'd offer that affidavit as necessary.
Yeah, I mean, I'm not going to take the affidavit as an exhibit. I'll certainly hear her testimony, so you
Sure.
can elicit whatever you wish.
Very good. Thank you, Your Honor. That's fine. Thank you. Now, as the relationship kind of winded down between yourself and Ms. Gattani, how did she treat you?
She made threats to me. She called me and she threatened me, and she told me that I needed to shut my mouth and be quiet.
Did she threaten to murder you?
Yes, she did.
Did she threaten to murder your kids?
Yes, she did.
Yes, she did. Yes, she did, Judge. She threatened. And I'm going to throw in some sniffs in there, too. Because it gets me very emotional that I have to sniff and fake cry. What are we listening to? What are we listening to here?
Were there more than 3 incidences of this type of behavior from Ms. Gattani?
She's the Marie Russell of witnesses. Oh, my law. This is bad.
Yes.
And did that prompt you to take some advice and go to the Attleboro court for an order?
Yes, it did.
And you got a criminal harassment order on her?
Yes, I did.
And that was fairly recently?
Yes.
When was it?
December 10th, my birthday.
And Ms. Gattani went there and she tested.
I had to spend my birthday going to the police station. And then I went home and I bought myself a cake. And I lit the candles and I blew them out all alone. That was my birthday. That was how I spent my birthday. My birthday. My special day was ruined going to the police station.
Justified, right?
Yes, on December 24th.
24th
For the two-party
hearing. Got it.
Yes.
Thank you. And you witnessed her admit some things about your relationship and what happened, right?
Yes.
Did she admit threatening to murder you and your children?
Yes, she did.
What'd she say?
She admitted into first when my lawyer asked me if there was any criminal charges pending, I said yes. And then the judge stopped and advised Ms. Gattani of her rights. And she went into great detail and explained it. And then when she got to the December 10th date, she said, I highly recommend and urge you to stay quiet. And she did not listen to the judge. She admitted to everything. She admitted that she felt remorse. She felt ashamed of her actions of like threatening to come to my house.
How dare she be honest under oath? I mean, if you think this woman is telling the truth.
Well, think again.
Yeah. Yeah, exactly.
She threatened to kill me. She threatened to rip my fucking head off and to come to my house and murder me and my children.
How many separate incidences were there of that kind of behavior from Ms. Gattani towards you?
There were several.
Can you just put a little more than several on it? What are we talking? A dozen, 8, 10, 6?
3.
3? Okay. What about calls from a block number?
Yes, yes. She admitted to Officer Kelly from the Mansfield Police Department. I did receive a phone call from Officer Kelly, and he stated to me that Ms. Gattani went down to the Mansfield Police Station and that she admitted.
I'm not going to accept this testimony.
Hold on there. I'll ask you another question.
Okay.
Next question.
So just what you saw her say, tell the court just in general, the important things that you saw Ms. Gattani say right out of her own mouth.
She admitted that that was her on the recording and that she threatened to murder me and my children.
Nothing further. Okay, thank you.
Ma'am, this is your opportunity. If you have any questions for this witness, you may inquire.
This is when you really, need a better, you need to have the audio from that, from that call-in show. It pays to be prepared for these things.
Isn't it true that you went on a talk show the night that you claimed that I called you?
Yeah, Tammie says RG sounds a bit like Gypsy Rose Blanchard. She talks with the baby voice. And you know who else uses the baby voice? She's on death row for killing her children, Darlie Routier. She talks with a baby voice too. It's a major red flag when you're talking with a baby voice for me.
I made threats to you.
Not that night, I did not. It was the day before.
It wasn't that night.
It wasn't that night. That was December 9th. When you threatened to murder me and my kids, it was December 10th.
December 9th was the talk show. Yes. And you went on a talk show.
Yes.
And you called in.
I believe it was at night and it went into the 9th to the 10th. So it was at late night, but.
I was asked to call in, yes.
You were asked to call in. By whom?
By the moderator and the hosts of the shows. They asked me to call in because you and your friends have been attacking me on Twitter for over 2 months. And I don't have a Twitter, and you knew that, and everyone knew that.
Well, if she doesn't have a Twitter, then she wouldn't see it. I'm sure if I'm attacked on, I don't know, some Blue Sky or some social media place that I don't go very often, I'm not going to see it. Now all my enemies are going to run to Blue Sky to attack me. But you won't see it. If you're not on there, it shouldn't bother you. You knew I wasn't on there. So good. It shouldn't bother you then.
Realize that there is a recording of this entire show on YouTube?
Yes.
So you're stating under oath.
There's a recording of what?
The show that you called into.
I mean, I haven't seen it. I just called into it.
You're aware that it was recorded.
There was, all I talked about was how my son saved your children 3 times from drowning.
3 times. 3 times. Who's almost drowned 3 times?
Oh, they almost drowned 3 times. And they had to save them.
Drunk. And
I'm asking you if you're aware that it's published online.
I don't know if it's
claiming that
published
somebody asked you
online.
to call in.
I don't know if it's published online or
So
not.
you called into the show, and one of the first things you said was that you have been involved with the Karen Reed case, that you initially believed that she was guilty, that you no longer believe that, and that Turtleboy loves you. Did you not say that?
I did not say that.
So if we were to pull up the show and play it today, we would not hear you say that Turtleboy loves me.
Turtleboy loves me? I didn't know.
So it's not true that you flipped sides, so to speak, for lack of a better word, went from being an anti-Karen Reed person or anti-Turtleboy person to a pro-Turtleboy person before you called into that show and made several statements trying to help his case against me publicly on chats on YouTube, various YouTube shows.
I wasn't trying to help him. I have my own freedom of speech. I was lied to by you.
I wasn't. So anytime someone's telling you what they're not trying to do, there's an admission in the negative. I wasn't trying to help him. Of course she's trying to help him. This is just straight up some perjurious testimony, in my opinion.
Kate. So yeah, I stopped listening to you guys. That made you guys upset. I didn't follow suit. I had my own opinion. I started looking at the other news channels.
Do you have any proof of any?
Guys, a miracle has occurred. Her sniffling and crying has miraculously healed. She's miraculously able to talk in full voice. Well, partially full voice because she's still talking like a baby. But she's baby voice is fully back, no sniffles. Amazing. Well, she's talking about the same subject.
Anything other than cordial interactions between you and I before the night that you called into that show, talking about my children and making up lies about my children?
I didn't make up any
Do you have any
lies.
proof of anything other than cordial interactions between you and I before that night?
I have a recording. Yes, I do.
Other than that night, do you have any proof of anything other than cordial interactions between you and I?
No.
So there's nothing except cordial interactions in text messages, on Messenger.
When people talk on the phone, you don't record them. When you talk, you're a very smart person. So when you don't make your threats in writing, you say it in person to that
Isn't
person.
it true that you testified under oath at the restraining order hearing that I made a threat to you on a specific day, and later that day I provided evidence where you texted me telling with heart emojis and asking how I was and were being friendly with me this very same day that you claimed that I threatened you?
We were talking on the phone. That was prior to the end of the phone call is when you made the threat. So when I sent the text messages.
So when I sent the text messages, I just wanted to give the person that just threatened me lots of heart emojis and love emojis.
The text messages didn't go through until we hung up.
Isn't it true that you called into the show that night making up lies about my children because your friend...
What is this, snail mail? The text messages didn't go through? I sent them before. How long? Wait, this is the problem with cross-examination. Again, another example. Lindsay's on one thing, on one switch. She wants to get her questions asked, but she's not listening to the answer. How long does she think a text message takes to go through? How is that even possible?
Had
That's not
private
true.
probate documents released and believed that it was me that posted them, and that you
No.
conspired to call into the show and make up lies about my children.
No.
And try to support the defendant here.
No, that's not true.
Isn't it true that this is retaliatory and you're making this entire story up in your affidavit about this conversation where I allegedly told you that this assault never happened?
That's not true.
I have no further questions, Your Honor.
Okay, thank you. Any redirect?
No questions, Your Honor.
Okay, thank you, ma'am. You may step down.
All right. So that's where we're going to end it. I'm just going to play this again.
Ma'am, this is your opportunity.
Just so you can hear it one more time. Right at the end here. She said she never said that Turtleboy loves her. Let's take
I'm friends
a
with
listen.
Meredith. And so
Meredith is
whoever
Turtleboy's girl, right?
yes. And Aidan knows about me. I've had many conversations with Meredith. Aidan loves me. We're all good.
Well, good. It's like a different person than the baby person testifying. Isn't it? All right, that's what I have for today. We may go over Aidan Kearney's testimony. We may skip it. But I'll be back tomorrow at 6 p.m. Eastern. Have a great night, everyone. Thank you for listening. See you tomorrow at 6 p.m. Eastern.
I hit my boyfriend with a car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. biggest hit yet. I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system I clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mark. My innocence fraud campaign is my biggest hit yet. John, you were my mark. My innocence fraud campaign